All right, good morning, everyone. We're now live on YouTube. Let's get started this morning by calling our docket. Mr. McLaughlin, you have an announcement.
Yes, sir. I have a quick one case. It's a CL 21-3042H Bank of America versus Garnet Bendlis that we're seeking a default judgment in.
All right, is Garnet A. Bendlis present? Garnet A. Bendlis. If you're on mute, please unmute yourself. Garnet A. Bendlis. Bendlis. All right, court's going to take judicial notice of all documents in the court's file, including the filing of this action on August 31st, 2021. A citation was issued same day, August 31st, 2021. Defendant was served September 9th, 2021. It was returned to the clerk September 14th, 2021. It's been on file for the requisite period of time. There's been no answer on file. The name of Garnet A. Bendlis was called out 3 times. There being no response, you may proceed with your default.
In this case, Your Honor, we believe that the defendant had opened up a credit account with Bank of America. They subsequently defaulted on it after making their last payment on July 5th of 2020. The account was closed and charged off with a balance of $7,825.75. We're seeking that amount in damages plus costs to the court. We're asked court to take notice of the business records, non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Carlos?
Yes, Judge, I was going to point out there's a gentleman there under the name Garnet. I don't know if he can hear us.
Garnet.
With a white shirt.
All right, is that you, sir? Garnet, you're on mute. Garnet, can you please unmute yourself?
Okay. Hello. Yes, I'm here.
Is that you, sir? Garnet Bendlis?
Yes, sir.
I hope I pronounced your last name correct.
Mm-hmm.
All right. How do you pronounce your last name? Is it Bendlis?
Bendlis.
Bendlis. All right. Mr. Bendlis, thank you for logging on. Have you had an opportunity to visit with anybody or any representative from Bank of America, sir?
No, I haven't, and I have not received anything. To be honest with you, I was out of the country. I guess when all this stuff that was sending to me and stuff, I was out of the country because I with issue with COVID, and I was out there for a while. So actually, 3 weeks ago is when I found out about this, that I have to go to court or something like that. So until now is when I know about this stuff, about the court stuff.
All right.
So, but I've been trying to this is something that I'm disputing.
Okay. Let me do this. Mr. McLaughlin, obviously he signed on. He was here. I apologize for
That's fine.
making you go through the whole process of reading that into the record. I should have interrupted and seen him, but I didn't see him. Nevertheless, I'm going to treat his appearance here today as a general appearance. I'm going to go ahead, Mr. Bendlis, and give you an opportunity to visit with Mr. McLaughlin so that you all can exchange information about how best he can get with you to discuss this case. I'm going to reset this case for 60 days down the road.
Thank you, sir.
April 27th, 2022, 9:30.
Okay.
All right. And Mr. Bendlis, I'm going to put you and Mr. McLaughlin in a breakout room right now. So
After we exchange information, may we be excused?
You're both excused after you all can exchange that information, okay?
Thank you, sir.
All right. Let me go ahead and put both of you in a breakout room. You're going to get an invitation here, Mr. Bendlis. Please accept it. At the same time, please know that the reset date is April 27th at 9:30, okay?
Okay.
All right. Mr. Reyes, what do you have?
Good morning, Your Honor. Judge, I'm here on F 442918-8.
All right, that's in the interest of Eileen Leonard Arriaga Bernal et al., a child.
Yes, that's correct, Judge. I was just retained to represent Isidro Elizardo Arriaga, the father of the child. And I would be requesting more time, Your Honor, since I was just retained on this matter.
Mr. Gomez?
Antonio Gomez representing the mother, in this case, Ms. Juana Bernal. I have no objection to additional time, but one of the issues in this case, Your Honor, and the reason that it was brought over from the child support court to your court on an appeal is that the Attorney General's office used a minimum wage presumption to set child support for this gentleman while he was working up in the Houston area, where the wage scales are considerably higher than they are down here. And we asked that he produce evidence of his income, and he has been resistant to do that. So now that he's got counsel, I'm bringing this up so that his counsel understands what at least one of the issues in this case is.
Mr. Reyes, obviously now you're involved. You've heard what Mr. Gomez is requesting. Can you provide that to him within maybe 2 weeks, and then we can start working and narrowing down the issues?
Yes, Judge. I'll make every effort to make sure that we provide that information to Mr. Gomez promptly.
All right, let me set this up for 30 days down the road, and if you can get that information, wage information to Mr. Gomez here within the next 2 weeks. Obviously, he may still need some time to get it, and you're now on top of it. So I'll give you 2 weeks to do that, and then set this up for 4 weeks down the road.
Sounds good, Judge.
April 6th.
That is all I have before this honorable court. May I be excused, Your Honor? And at what time is it on April the 6th?
9:30.
Thank you.
That's all I have as well, Judge. May I be excused?
Both of y'all are excused. Thank you.
Thank you, Your Honor.
Mr. Alcantara, are you here on this case as well?
Yes, Judge, I was here on this case as well. I have no objection. If I may be excused as well, please.
Yes, of course. Thank you.
Thank you.
Right. Anyone else ready to have their case called? Mr. Garza?
Your Honor.
Oh,
Yes,
sorry.
yes, Your Honor, but I don't know that co-counsel Catherine Garcia is on the line yet, Your Honor.
She's on the line. It looks like she's on the phone though.
Oh, there she is.
I was actually just speaking with the client, Judge. We were discussing some issues. I don't know if a breakout room might get us quicker,
Okay.
or do you want to continue this way, Mr. Garza?
Whatever Your Honor decides. I mean, I don't want to bog down your calendar.
No, I could put Mr. Garza and Ms. Bettis in a breakout room. Y'all can discuss, and then when you're ready to come back, you just come back and let me know. And I'll continue with my docket.
Thank you.
Thank you.
Sure. All right, Mr. Garza, accept the invitation. All right, Mr. Kerr, you were ready to make an announcement?
Good morning, Your Honor. CCD 0626H. And I do see that the defendant appears to be online, Antonio Trevino.
All right, yeah, so it's number 13 CCD 0626H. Hidalgo County Drainage District number 1 versus Antonio Trevino and Sheila Trevino.
That's correct, Your Honor. Greg Kerr for plaintiff, Hidalgo County Drainage District number 1.
All right, Mr. Antonio Trevino, you're on mute. Can you please unmute yourself? Mr. Antonio Trevino, can you unmute yourself, please? What do we have here, Mr. Kerr?
This was set for a status. I understand the landowner filed a couple of letters to the court. I was not copied on any of them, but I understand that there is a general.
Oh, this was a case where he was objecting to the fact that y'all proceeded without him being present, or that he had given notice to your office that he had COVID, that he was unavailable, and that the hearing proceeded without him. I'm
I
not.
don't know that there was a COVID issue, but we, and I can just take you through some of the early procedural history. The defendants were served with the petition and the order setting hearing. We're obligated to do that 20 days prior to the commencement of the hearing. On the day of the hearing, approximately an hour, maybe 2 hours before the hearing, Mr. Trevino called me and said he can't get out of work, is what he indicated to me. And if he asked me if I would tell the commissioners he was requesting a continuance, I told him I would tell the commissioners that, but that I would not be agreeing to a continuance. And so we did proceed. The commissioners entered their award. The award, as is required by law by the Texas Property Code, was sent via certified mail to the landowners. And no objections were filed within the requisite time period. And so I submitted a proposed judgment in absence of objections, and that was signed, I believe, last week, Your Honor.
You said that they didn't object within the requisite period of time. Are they untimely in filing any objection? And so legally, the court has no other option but to accept and approve the finding of the commissioners?
That's right. In the absence of an objection filed on or before the Monday after the 20th day that the award was sent via certified mail to the landowner, then the judge is to enter a judgment in the case.
Okay. And they didn't obviously file it within that requisite time period.
They did not.
Mr. Antonio Trevino, you are on mute. You have your camera off. I believe you are the respondent in this matter. Can you please unmute yourself, or the court will make a ruling on this case? Antonio Trevino, you're on mute. Carlos, will you translate that into Spanish, please?
Antonio Treviño, si puede encender su cámara y su micrófono, por favor. Antonio Treviño, si puede encender su micrófono y su cámara, por favor.
All right.
I mean, Your Honor, I can wait a little bit, and if he can figure out the technical issue, I don't mind giving him a second to do that.
Okay, let me go ahead and just call a couple more cases and then we'll come back. I don't want to keep you as well.
Thank you, Your Honor.
Mr. Rigney, are you ready to have your case called?
Morning, Judge. Yes, sir, I am. I'm here on EL 187130H.
Juan Pequeño, Your Honor, here on behalf of the defendants.
All right, this is Kemas Far Jackson LTD versus Valley Mattress Sales LLC and Richard Finney.
Yes, Your Honor.
All right, this is plaintiff's second motion for summary judgment. Last time we were here, Mr. Rigney, what was the reason for us passing the summary judgment since it's your second motion?
The first MSJ, Judge, I think we established that there was a breach of contract. The only thing was that there was a question on the damages that counsel at that time had propounded some discovery, and I had given it to him, but he said he hadn't seen it, so I sent it all to him again. I propounded all the discovery, everything that establishes all damages, Judge, and I have submitted those to the court with my second summary judgment evidence as exhibits. Exhibit number 3 has all the responses to his request for admissions, his interrogs, his request for production, and his disclosures. And I believe that now, Judge, there is no material issue that would prevent the issuance of a summary judgment. We've established with all the exhibits, Judge, exhibit 1 through 8, we've established that there was a contract. We've established that there was a breach of contract. And now we've established by evidence all of the damages that we're claiming. So at this time, Judge, although I believe that possibly Mr. Finney may have deceased, I'm only suing him as a guarantor. So I am asking for a judgment against Valley Mattress Sales LLC, and that way I can present that judgment to the estate of Mr. Finney, if indeed he's deceased, as a guarantor.
Okay. Mr. Pequeño, you are the respondent, you represent Mr. Finney or Valley Mattress Sales LLC?
Judge, yeah, a little bit of history here. So Mr. Ben Guerra was representing both Valley Mattress Sales and Richard Finney. He took on other employment and needed to withdraw from the case. So I was just substituted in here recently, which is in part why we were seeking a continuance. I just appeared in the case about 2 weeks ago. It is my understanding that Richard Finney is deceased and he passed away sometime in 2021. We do not have any knowledge as to who is going to be a representative of his estate, if an estate's been open. According to the rules, basically a seer fact has to issue before the case can proceed, right? So there's that aspect. As far as the history, my understanding of the history, Judge, is the prior summary judgment was denied outright. There was no partial summary judgment finding that there was a breach of contract and there was only an issue as to damages. It was denied outright. That's from my review of the file. So, in part, we're seeking the continuance because of these issues with respect to Mr. Finney and me now just getting involved. However, we did file a response reiterating a lot of the points that Mr. Guerra pointed out in the prior summary judgment, which, first of all, Judge, the person suing on this landlord-tenant relationship is not the owner of the property. And that issue has not been addressed at all in any of the summary judgment evidence. In addition to that, Judge, a lot of the summary judgment evidence that has been presented is riddled with issues. There are, in the affidavit, provided nothing but legal conclusions, factual conclusions. We've asserted all of our objections in response to the summary judgment. Not only that, but the damages, Judge, if you look at the damages calculations, none of the documentation has been authenticated in any way. It's just attached. There's no authentication as to what records those come from, who they're from, or anything of that nature. So we've objected on numerous grounds related to that, but they all reference Mattress Firm. Our entity is Mattress World. It's Valley Mattress Sales LLC DBA Mattress World. So on its face, Judge, the summary judgment evidence raises fact issues on its face. That's me not having been given the opportunity to really dive into all of the issues here and look at what further defenses there are, given the limited time I've been involved in the case. But just on its face, there's factual issues. The ownership issue, which Mr. Guerra already raised, and which I would assume was in part the basis for the denial of the prior summary judgment. In addition to the issue with damages, there's also in the affidavit, they indicate, damages of, I think it's like 57,000. But then when you look at their own summary calculations, they say that, the amount owed by Mattress Firm, again, a separate legal entity, is 38,000. It doesn't even correspond with what they're asserting. So I think that the summary judgment should be denied outright, just based on the factual issues we've raised on the face of the evidence being presented.
Okay, so you're not asking for a continuance. You just made your argument. Is that correct? And you'd like for me to proceed then today?
That's correct.
That's your argument.
Well, and what I would say, Judge, is I think that, and it sounds like this issue's been resolved, but as with respect to Mr. Finney, if he's not proceeding, I think I'd be inclined to request a continuance as to him. It sounds to me like Mr. Rigney is not proceeding as to Mr. Finney currently.
Okay. Mr. Rigney, so then I'll allow you to respond, since we are having, I guess, we're not entertaining a continuance and we are having the summary judgment arguments. Because I think I was confused a little bit. You mentioned that Mr. Pequeño may be asking for a continuance. I heard he was asking for a continuance, but then he got into arguments and then defending the summary judgment. And then ultimately, I guess we're having a summary judgment hearing. So I'll go back to you and allow you to respond to his statements, and then we have the summary judgment hearing.
Yes, Judge. Thank you. Now, I haven't seen any response from him. He says he filed something. I don't know when, but I haven't seen it. I'll believe he did file it. I don't know when he filed it, but the fact is Judge, previously, yes, the court did outright deny the MSJ, but That's only because I didn't ask for a partial MSJ on the breach issue. But at that point, if the court recalls, we had established there was a breach. The only thing is counsel wanted to dispute the damages because I had not provided, according to him, any proof of how we calculated the damages. And in this particular case, Judge, Exhibit 1, we have a lease. It is signed by the parties. It is leased to the tenant. It's called Valley Mattress Sales, LLC. And then it says the tenant's trade name is Mattress World. And that's who we're suing, is we're suing Valley Mattress Sales, LLC. And on the bottom, as far as the landlord, on one part of the lease, it says Kima. And then on the bottom, where the landlord's signature is, they wrote in the S, so it's Kimas. It's just a misnomer, where I guess at one point they forgot to type in the S, but then on the signature page of Exhibit 1, let me go back to the signature page. I believe it's on Exhibit 1, where the landlord signed, it does say Kimas. So there's no issue of the right parties or wrong parties. And then
what are we talking about here, Mr. Rigney? Like what obviously Valley Mattress, I'm assuming Kimas provided mattresses to Valley Mattress Sales LLC. Is that correct?
Kimas owns a building, and so affidavit number 2 states the facts. So Kimas owns a building and leased a 3,000 square foot space located on South Jackson Road in FAR to Valley Mattress Sales LLC, DBA Mattress World. And then they signed a lease for 5 years with a base rent of $5,500 for the first year. And then it had an escalation clause in it. And all that's in Exhibit number 2, Judge. And then the leasee, they moved out as of October of 2017. So they were only there just a little over a year. And the building was vacant. And then the landlord released the building. And what we're suing for, Judge, is only the amount of rents that were lost during the vacancy period of $59,840. We're asking for releasing expenses of $16,000. And all of that's in the discovery of how we came up with those numbers, and commissions and fixing the building for the new tenant in the amount of $3,500. So the liquidated damages amounts to $79,340. But it establishes, there's no issue, material fact. The people leased the building. We have a contract. There's no issue whether they actually breached the contract, because they did move out and they're not denying it. So, and the damages are there. So we've established the elements of the cause of action, which is a breach, a contract, a breach, and damages. So that establishes the basis for the motion for summary judgment, and all of the propounded discovery establishes exactly how we calculated our damages, and we're just asking for that. Now, it may be, honestly, it may be an uncollectible judgment if Mr. Finney's dead, but my client wants me to, bring this case to conclusion.
Judge, if I may respond, I did file a response timely with objections, the request for continuance, et cetera, and Mr. Rigney should have been served with a copy. I'll have to check and make sure that was done. It was my understanding that was done, but that would have been filed last week. As far as what transpired at the prior hearing, Judge, I can't really comment on that since I wasn't involved in that. I don't have a transcript of that, but the file that I was given shows a denial of the summary judgment, so I can only assume that it was denied entirely. And so one of the issues that, again, and I'm going on, the limited time I've had to kind of go through everything here, is that the property is, and we attach this to our evidence, the property is titled in the name of Brownsville West Sea Limited. But this landlord that's purporting to lease is this Gemas, or however you say this entity's name. And so based on that, and this was the issue that Mr. Guerra raised previously, is they cannot establish this landlord-tenant relationship. What gives them the basis to lease this property? Aside from that, Judge, just again, looking at a lot of the documentation provided, this entity is Mattress World. The documentation refers to Mattress Firm. If you look at the damages and what are set out on the calculations, it comes up with a completely different amount, a lesser amount, actually. It says 38,000. Let me pull it up here.
Let me ask you this, Mr. Pequeño. So you telling me that mattress sales, Valley Mattress Sales, doing, and obviously Mr. Rigney's argument is that they're doing business as Mattress World. They're not one and the same?
Valley Mattress Sales LLC is DBA Mattress World. The documentation is referring to Mattress Firm. Mattress Firm is a different entity, Judge, that has nothing to do with our entity.
What document are you talking about that says Mattress Firm?
Let me pull up the if you go to the plaintiff's exhibit 8.
Do you have it? Do you happen to have it on your computer that you can share the screen so we can just see it?
Yes.
I can allow you to share?
Yes.
Go ahead.
Just give me a second. It might take me a...
Oh, Judge. Yeah.
I have too much stuff open on my, but here it is. So this is the payment history, Your Honor. This is their exhibit 8. And our position is that it has not been properly authenticated as a business record or anything else for that matter. But as you can see here, Judge, it's referring to Mattress Firm. Now, again, that's a nationwide entity. We have no affiliation with Mattress Firm. And there's a payment history here. One thing that's not accounted for in this payment history is our security deposit and how it was applied. That was something that Mr. Guerra raised at the prior summary judgment, and I would suspect is one of the reasons why it was denied. And it's not addressed here. We don't see any application of our $6,000 security deposit. And then the exhibit, let me see here. So I don't know if you can see now, this is exhibit, it's a spreadsheet. I believe it's plaintiff's exhibit, should be plaintiff's exhibit 7, Your Honor, also refers to Mattress Firm. And I can't honestly make sense of this calculation, Your Honor, but here at the bottom, it says here, and again, we're not Mattress Firm, but just to point to the court why this should be denied on its face, is it says here, difference owed by Mattress Firm to Gemas, $38,463. Well, that doesn't line up with what they've asserted. So there's all sorts of stuff, again, just on its face, Judge, that don't add up, that raise those fact issues that I think require that the summary judgment be denied.
Okay. Mr. Rigney?
Judge, I mean, he's arguing, I guess, semantics. The exhibit 8, which says Mattress Firm, and exhibit 7 that say Mattress Firm, those are just Excel spreadsheets that my client, that's how he internally recognized them as the Mattress Firm, business that's there. But, we're not suing Mattress Firm. We're suing the people who signed the contract. We're suing the people who actually conducted business there. The fact that he refers to them, I mean, he could have put the mattress people. He could have put, whatever he wanted. That's just how he recognized who his tenant was. So I think that that's a illogical argument. And then the number 7, that he says the numbers don't add up. If you go through all the exhibits and the empty months and all that, then it adds up. And exhibit number 7 is only there to show that all the months that were vacant and the months that they didn't pay. But we have a calculation there that shows how we came up with our money, or the total amount of damages, and it absolutely adds up. So, I think it's just, and then he's arguing against his security deposit. Well, we all know that when you break your lease, you lose your security deposit. I mean, he's arguing over a $4,500 security deposit in exchange for an $80,000 judgment, or to hold up an $80,000 judgment. But the terms of the lease provide, if you break your contract, you lost your deposit.
So there's no disputing, Mr. Pequeño, that they breached their agreement. There's no disputing that. Is that correct?
Well, I mean, my understanding, again, Judge, Your Honor, is Valley Mattress Sales, DBA Mattress World, had a lease at this location. Again,
and they and that's who you represent.
Correct. Not Mattress Firm.
Correct. And let's just assume Mattress Firm is that look, I can easily give Mr. Rigney an opportunity to to fix that and submit an affidavit, and we come back in a week and do that. But I just want to get to the facts, right? Without assuming that we're going to be held up by the semantic of mattress firm, mattress sales. I understand that it's a different company, it's a different entity, right? But how the landlord views it, maybe like Mr. Rigney said, he could view it as, the mattress guy, right? And that doesn't necessarily make it different. So the question is, did your client did he enter into a contract for the rental of a unit, and did he breach?
There was a contract with this Kemas entity. Again, one of the issues though, Judge, is this is a landlord-tenant situation, and the landlord, which is Kemas, doesn't even own the property. And that was something that was raised previously and is raised now. I mean, how is that not an issue on its face? So
Judge, he just stopped from making that argument, Judge, because they entered a valid retail lease agreement with Kemas Far Jackson Ltd, and that's who's suing them. And this is, it's not a landlord-tenant relationship that says we're trying to evict him. All we're trying to say is you owe money to this entity who's the one who leased this property to you.
But it is a landlord-tenant relationship, Judge. And so here's the thing, the copy of the lease they attached, Judge, isn't even signed by Kemas. So
it is.
The copy that's attached, Judge, and I have it here, is Exhibit 1.
Somewhere I saw it signed. There's one of them is not signed, and then there's another exhibit, Judge, that has a signature page of the landlord, and it's on exhibit. One of them has the signature of the landlord on another exhibit, Judge.
Right, I remember seeing it. Eddie, can you pull that up?
It was signed in two parts, Judge.
Right, it's almost like one person signs it, they send it to the other copy, the other person, he signs it, and then they get the signature of both. And
correct.
That happens all the time with divorce
correct
or what have
and like it happens all the time, and then that still didn't keep them from taking the keys and opening a business and selling mattresses until the day they moved out. And so I think they're stopped from making that argument. They entered a contract with a guy that says your landlord is Kemas Ltd. They gave him a deposit. They took the keys from them. They conducted business under that lease agreement. And now for them to come back and say, well, he doesn't own the building. Well, the landlord doesn't necessarily have to own the building. He just has to be the landlord. And they entered a contract with this landlord.
Okay. I did see, Mr. Rigney, and my staff is pulling it up on the side computer. I did see one that was executed. I think it's in the exhibit number. I'm looking at it now. It's exhibit number 5, Judge, and that one's signed by Carl Samick, and that one does say Kemas Jackson Far Ltd, president of STAS, whatever that is. Mr. Pequeño, can you go to exhibit 5 right there? There it is. That's the one we're looking at.
Yes. And I think that was one of the issues that we took, Judge, is, it's one page, I guess, and looks like this is in response to discovery. We had objected to these, to them using their own essentially discovery responses, which is prohibited under the rules, to as evidence toward their summary judgment. And so we've seen this signature page, but the completed copy and why the lease attached to Exhibit 1 only has one signature is odd to us. And so we just raised that issue.
Well, let me ask you this. I mean, obviously, it would be a completely different story if your client hadn't signed it and it was signed by Kemas. But in this situation, it wasn't signed by Kemas, but yet your clients did, in fact, go in there and utilize it as was originally intended, right?
I mean, yeah, and I think, Judge, if we're getting down to the issues, the damages, even just looking at the damages, as I said, on its face, aside from the mattress firm issue, the numbers don't make sense. It doesn't jive with what they're asserting. Their own documentation is raising a fact issue as to amounts. So if the court wants to focus solely on this issue of damages, our position is they've not met their burden. And the other aspect of this is that, you know, there's the duty to mitigate. Have they proven that they've mitigated their damages? Again, that goes back to some of the objections we've asserted as far as conclusory statements in the affidavit of, I believe, Mr. Rubio, who doesn't really establish personal knowledge. He didn't sign the lease. So it's not clear what involvement he has. But, you know, again, it just on its face, there's just so many issues that have not been accounted for. Have they mitigated their damages? Have they shown they met their duty to mitigate damages? And have they accurately set out what their damages are? On its face, this as set out, this motion has not.
Judge, I think the affidavit of exhibit number 2 by Mr. Rubiano, who's manages the property for Kimas and sets out the terms. It sets out specifically when the property was released in order to mitigate the damages. I mean, you don't just release a commercial property the next day. Sometimes they sit empty for years. So this one sat empty for a while. It sat empty from October of 17 through May of 2018. And so on there, it breaks down that, you know, basically what we're looking for is the monthly rent for all of those months in a total of $59,840. And then it has the releasing expenses of $16,000. Then it has the $3,500 that they had to give.
What do you mean by releasing amount? Like, what is that releasing? Like, what did you call it?
Releasing expenses.
Yes, what is that?
On commercial properties like this, you know how you have to hire a real estate agent, and then they charge you a percentage of the contracts to lease properties commercially. So when you hire Caldwell Bankers to lease, which is the one that leases these properties, Caldwell Bankers takes a commission based on the contract that they get a tenant for. And so that's part of that releasing expenses, Judge.
So Judge, and that's part of the issue, is that a lot of these things are not spelled out. We have that exact same question, and that was raised, I think, by Mr. Guerra the first time. And we essentially reiterated a lot of Mr. Guerra's points. And that's another point, is that the 6,000, you know, to just say poof, it's gone. I mean, well, no, where did that go to? You're saying that you repaired the property, and why wasn't it applied to rent? If anything, that would reduce our rent. If you're saying you use it for damages, what damages was it used for? That's not been spelled out. The releasing expenses, there's no breakdown of any of that amount, Judge. And then I believe they provided this is, I believe, exhibit 5. And it's an invoice, and it's got the amount of, I guess.
This location got released to Girl Talk Boutique?
Yes, Judge.
Gotcha. Okay.
So
and in the request production number 5 that they produced to us, requested from us, it said produce the documentation supporting the alleged damages of the releasing expenses of $16,000. And we provided that documentation from, I think it was the Ruby Group or Rubiano Group or whatever it is that manages the property, as an affidavit of what they had to spend in cost to redo the lease agreement with someone else. So, you know, at no point did they object to our discovery. At no point did they come back and say, hey, you know, we disagree. The fact is they broke the lease, and now they just don't want to pay for the damages, Judge. And we mitigated our losses. We released it as soon as we could. And actually, I believe it even rented for less. It was released for less than the original judgment or the original lease amount, if off the top of my head, if I remember right. And we didn't, I'm not, you know, my client is not suing for the loss of the rent of the depreciated rent, but they're just suing for what's fair, Judge. They're just suing for the empty months. Most landlords who break a lease, they sue you for the remainder of the lease. And we're being extremely fair. We're only suing for what's right. It's the empty months. That's it. And if you go to the empty months, the math is there, Judge.
And Judge, just a couple of things. I mean, just to reiterate, there's the mitigation of damages. Have they shown that? But going back, I was trying to make this.
Okay, hold on. Let's talk about that because commercial property, it released within 5 months. Is that about the right amount?
No, October of 17. So it would be October, November, December, January, February, March, April, May. It released in 8 months, Judge. Sometimes they sit there empty for years. We were able to get they were able to get this one released in 8 months.
Okay.
So real quick, I wanted to make a point about, there's a couple things here. There's a lot of things that Mr. Rigney has said that are not part of the summary judgment evidence. So I take issue with that. Explaining what the releasing expenses are, none of that is explained in the summary judgment evidence. And as you know, Judge, we're stuck with looking at what's in the summary judgment evidence. So that's not explained. But going back to that, and I think you can still see my screen, Your Honor, this I guess releasing expenses that they're trying to assert, which again we can't make sense of it, but I'm just pointing this out. This 16,200 is from Ricardo Rubiano. That's the same person making the affidavit. So this guy paid himself a commission to go release his own property. I mean, none of this even makes sense.
I never said Rubiano owned the property. Rubiano is a leasing agent. But like I said,
but
like
prepared the affidavit, Judge. Ricardo Rubiano is the manager of Quemas Far Jackson Limited. I mean, how does that even make sense?
They're different entities. This is Ruby Group LLC by Rubiano, where he is a real estate leasing agent. He makes a contract. And like I said, if you see the term that they made for Girl Talk Boutique, the releasing of 60 months at $270,000 value, they charge 6% of the lease value as a commission for having obtained that tenant. And $15,200 comes from. They wanted proof of it, proof that my client, which is Quemas LLC or Quemas Limited, incurred a $16,000 expense, and we're providing an invoice from the guy who billed it for them. What's the problem? Why don't they like that? The fact that they have it.
And again, none of that is explained, Judge, in the summary judgment evidence. It's all
mandatory.
Okay.
It's mandatory. It's an invoice to Quemas by a separate LLC for releasing and the commission of leasing that to Girl Talk Boutique. My client would have not had to pay that commission had Mattress World or whatever it was not broken their lease.
A commission to the manager of the same company. I mean, again, Judge, there's just too many things on its face that raise fact issues as to this.
All right. Let me do this. Let me put you all in a breakout room. I'm going to join you in that breakout room. Okay.
Yes, Judge.
Rigney. I'll join you all there.
Let me join.
Good morning, Judge. Can you hear me okay?
Yes, we can hear you, Mr. Cutler. Judge will be right back. He's just staffing a case.
Okay, sounds good.
Is that Antonio?
Okay, now they got video, audio, everything's on. Literally on. Who's your grandpa? Come on.
Person under Antonio Trevino, which case are you on?
Case number CCD 0626H.
Okay, if you can mute your microphone, we'll be right with you.
Thank you.
Carlos, good morning.
Good morning.
I don't know if the judge wants us to stay on, but JR and I have reached an agreement. He wanted me to make an announcement that we can put it on a Rule 11. Do we want to stay on and put it on the record?
Let me find out. Give me one brief second.
Okay.
Ms. Perez, so Rule 11 will suffice.
Perfect. We'll send it over to you.
Thank you.
Thank you.
All right, Mr. Pequeño, Mr. Rigney, both of y'all are on mute. When you come back from the breakout room, you all are on mute. So very quickly, thank you for the opportunity to discuss this case. The court is of the opinion that I would like to hold off on making a ruling on the summary judgment and inquire from both of you as to whether or not your clients would be amenable to mediation before the court makes a decision. I know that Mr. Pequeño, your client is out of town. Mr. Rigney, we didn't actually talk about whether your client was local or not, but I'm going to grant the parties 1 week to be able to visit with their clients and reset this case for next Wednesday, the 9th of March, 3/9/2022 at 9:30 in the morning. And if it's possible that this can be resolved via mediation, an announcement will be made, and I'll allow the parties at arm's length to mediate before the court rules on the summary judgment. If it is not possible, if there is no, ability for the parties to even feel like they can come together, then the court will make a ruling on the summary judgment at that time. Mr. Pequeño and Mr. Rigney, both of y'all wanted to make certain, put something on the record with respect to judicial admissions. I'll allow Mr. Pequeño to go first.
Yes, Judge, we just asked that the court, take notice of our response on file and judicial notice of our response on file, our objections, and so on and so forth, and the exhibits we attach to our response to summary judgment upon the time that the court makes a decision on the summary judgment, should it go that direction.
All right, judicial notice will be taken, Mr. Pequeño, and thank you for that. Mr. Rigney.
Judge, same request, just take judicial notice of all the pleadings and exhibits on file, Judge, and for the record.
Judicial notice will be taken as well, Mr. Rigney. March 9th at 9:30, and y'all please confer with your clients and see if they would be amenable to some sort of mediation within the next 30 days. And if not, I'll take that announcement on the 9th at 9:30 in the morning.
Yes, Judge.
Yes.
I'll be in contact with Mr. Rigney.
All right.
Thanks. Thank you, Judge. May we be excused?
Both of y'all are excused. Thank you so much.
Judge,
Thank you.
All right. Mr. Kerr, let's go back and see if your client, I don't see him now.
Well, it wouldn't be my client, the landowner.
Oh, yeah, opposing counsel. All right. Oh, no, there he is. He has his camera on now. Sorry, let's go back. This is the CCD 0626H, Hidalgo County Drainage District number 1. Antonio Trevino, can you unmute yourself, please?
Yes, sir. Yes,
Okay.
Your Honor.
Perfect. I'm glad that we were able to get you on. Were you able to hear some of Mr. Kerr's arguments that he made earlier, or were you not available?
Not available, sir.
Okay, great. All right, I'll allow Mr. Kerr, if you can reiterate your arguments that you made before the court.
Yes, Your Honor. I was able during the break to see some of the recent filings Mr. Trevino made. I want to first point out to the court that we have been in contact with Mr. Trevino since January of last year was when we first made contact with Mr. Trevino. We sent multiple certified letter mailings that were received, including all of the requirements from the law. We're required to make the landowner's bill of rights, which outlines the process, initial offers, appraisals, final offers. And when all those things fail and we receive nothing back in return, no correspondence, nothing, no contact, it is then at that point that we file suit. I attempted to reach out to Mr. Trevino even prior to filing suit. And I believe we spoke and he indicated to me that he was not interested or he was not interested in selling the land. We filed suit. Commissioners were appointed. We served Mr. Trevino with a copy of the lawsuit, a copy of the order setting hearing of the special commissioners hearing. And then for the first time, anybody on behalf of the district received a phone call from Mr. Trevino the day of the hearing. It was probably 2 hours before the hearing that he called, spoke to my secretary. There was no mention of COVID issues. It was, and when he talked to me subsequently, it was he couldn't get out of work or there was a work conflict or something to that effect, but no mention of COVID. He did ask me to continue the hearing. I said I would tell the commissioners he was requesting a continuance of the hearing, but that I was not going to agree to it. As you know, Judge, these hearings had to take place for the Drainage District to obtain possession of the property. And that's a very important thing when we have drainage projects that need to be constructed. And so we held the hearing. The county clerk sent a copy of the award to Mr. Trevino via certified mail. No objections were made within the required time period provided by law. And as a result, I asked this court to do its mandatory duty, which is to enter a judgment in absence of objections, which has been done. Everything that's been filed since has been filed after, not only after the timeline to object was passed, but after the filing of our motion for judgment, entry of judgment, and the signing of the judgment. And so there's really nothing to do at this point. There's a final judgment, and it was based, and everything's been done in accordance with what we were required to do under the law. So I don't want this to seem like we just steamrolled somebody. We sent out, I got a binder full of letters that we sent out to the gentleman, and we received no response for now over a year until now. We are now seeing something filed in this case.
And let me ask you this, Mr. Kerr, was this a hearing that was conducted via Zoom or in person?
It was two of the commissioners, I believe, appeared via teleconference and one appeared in person, from what I recall.
Okay. But typically, though, that accommodation is made where you allow them the opportunity to appear because of our situation, right? It's typically done in person.
Absolutely, but when I cannot even get anything back from a landlord, we hear nothing. We can't convey that to them.
No, I guess I'm asking, and I haven't heard from Mr. Trevino, and in just a second, Mr. Trevino, I'll allow you to speak, but I just want to know whether or not he had the ability to appear via Zoom the way he's appearing now to request a continuance and didn't do that.
Up until the day of, no. The first time we heard of him was the day of the hearing.
Right, but I mean, you said I'm not going to agree to it, but you can appear at the hearing. I'm assuming, right? Because that's what I would have done.
Or you can come
and then say, "Time out, judges. I'd like an opportunity to get some more time, and here's the reason why. Please, grant me that time. And I know it's an inconvenience for you, but here I am requesting more time, and this is the reason." But that didn't happen.
That did not happen. And he has all of the phone numbers for the commissioners. I specifically told him you can contact the commissioners and ask for whatever you want. And I did tell the commissioners that he was asking for a continuance, but that I was opposed to it. And so I said, commissioners, do with that what you will. And they said, let's go forward.
All right. Mr. Trevino.
Yes, Your Honor.
Go ahead.
Me and my wife have not had our day in court. I'm here today to plead with the court to grant us justice and to give us a hearing to our case. I believe that we have been damaged and misled. I will briefly testify to the court why we believe we have been denied due process and by extension deny our day in court. Let me explain. My wife made the effort, even though she was ill with COVID symptoms, and called attorney Greg P. Kerr office and spoke to his secretary and explaining and pleading that we could not attend the hearing because she was ill with COVID symptoms. Mr. Kerr returned that call with our telephone records to show. I pleaded with Mr. Kerr to postpone the hearing so I could attend to my wife's COVID infestation. Mr. Kerr told me that he was going to advise the Drainage District officials and request a postponement. I was led to believe that it had been postponed. This was my understanding as a layperson, since I'm not an attorney. For the record, one of the documents that was filed through the court states that me and my wife attended the hearing, which is not true. It's not a true statement. I'm making this statement under oath because it is true. I called numerous appraisers and attorneys, and the majority of them did not answer their phone, possibly to Thanksgiving, Christmas, and New Year's holidays. The few that answered were extremely busy, and moreover, they did not do eminent domain. I was recommended to two appraisers, Arturo Palacios and Adelaida Gonzalez, both were extremely busy and they could not assist me. Finally, Adelaido Gonzalez, who is present here, has agreed to make some time in his calendar and has agreed to assist me and my wife, provided that I can preserve my day in court.
May I respond, Your Honor?
Yes, I just want to know whether or not he has counsel now.
Yes, Mr. Adelaido Gonzalez is sitting here next to me.
Can I speak, Your Honor?
Sure, go ahead.
Your Honor, it is common knowledge that if people pick up the phone, even now, it's very hard to find appraisers because of the influx of activity that's happening right now because of the inflation of the property values for a variety of reasons, okay? There are two appraisers that basically, and Mr. Kerr knows one of them because he dealt with him in court a few weeks ago, Arturo Palacios. Arturo Palacios and myself are probably the only two that provide a sense of some kind of help of justice for the people that don't have the powers to be behind them, do not have the powers of the state behind them. Now, the problem is that Mr. Palacios, and I cannot speak for him, but I know him very well, as well as myself, specialize in litigation-related stuff, including, but not limited to, eminent domain. And he just contacted me last night when I finally agreed because of to carve it, because I was called by 3 other appraisers that are mentored to help him out. So I went ahead and assisted them in representing him, provided that he preserves his day in court. And I made sure that I asked him, are you sure that what you're telling the judge, that it is true and correct and factual, that they're saying that you appeared and you did not appear? Because if you don't have your day in court, I can do all the appraisals in the world. It's not going to help you for anything. Okay, so I'm really willing and able to help him.
All right, so Mr. Gonzalez, I guess my question right now is, are you an attorney or an appraiser?
I am an appraiser.
Not an attorney.
Not an attorney.
Okay, okay. All right. Okay, Mr. Kerr.
Your Honor, I take issue with a lot of what Mr. Trevino I've never had any mention of COVID to me when he spoke to me. Never told him that I would contract the drainage district to cancel the hearing. I did say I would let the commissioners know what he was requesting, which I did. The reason being that there's no appraisers available. I mean, Judge, our first letters went out to Mr. Trevino, Mr. and Mr. Trevino back in January of 2021. We're talking over a year now. A year and 2 months since we first contacted Mr. Trevino, and we heard nothing. We heard nothing until the day of the hearing, at which time he said, I'm not going to the hearing, let the commissioners know. And so we're beyond the day in court, Judge. We are beyond the statutorily imposed deadlines that we are obligated to follow. We followed them to a T, and we proposed our judgment, and the judgment's been signed as it should have been. And so there's really nothing to do at this point.
All right, Mr. Trevino, did you reach out to any of the judges? And before, let me ask you this. Actually, this is an important question, so I'm going to place you under oath. Can I have you please raise your right hand? Do you sort of tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Did you, after speaking with, you may lower your hand, thank you. After speaking with Mr. Kerr and his office, or in his secretary, did you reach out to any of the judges to note your concern that you would not be available for the hearing?
No, sir, just the attorney.
So you did not reach out to any of the judges or make yourself available on the date of the hearing?
No, sir.
And to your knowledge, did Mr. Kerr tell you that he would pass the hearing, or did he tell you that he was objecting to the hearing, but you could call the judges as he's stated here today?
He told me that he was going to talk to the drainage district, number one, because I told him that I wanted to postpone it. He said he will relate it to them, that he was going to talk to them.
Right, that's his client, right? So if they want to proceed, and I could see where, they sometimes have an urgency in trying to, resolve these condemnation. These kind of condemnation hearings are cases where it's not a question of if the property will take, and the question is how much will the value of the property be assessed and how much will you be compensated for it, right? I mean, it's
Yes, correct.
for the greater good of the community, and so,
Yes.
okay.
Also, Josh, he never told us that we could attend through Zoom because I told him that he asked me about my wife and I told him she could not go. He didn't say that we could do it through Zoom. He did ask me because he told me, Mr. Trevino, I cannot go. They go, how about your wife? And I told him my wife cannot go. He didn't say you guys can do it through Zoom. He never said that. Never gave us that option.
Okay,
Can I interject this a little bit, Your Honor?
go ahead.
Just a side, I'd be willing to rush an appraisal beyond the normal protocol on my part to assist him to mitigate the time delay and rush this thing for giving him his day in court.
I can appreciate that, Mr. Gonzalez, but here's a problem, right? I have appointed 3 disinterested members of the community to hear this case. And one of the things that the drainage district has to provide is payment to those judges. And so it's one of those situations where, while I can understand the concern, number one, I have to look at the legal arguments of Mr. Kerr and say, do I even have the ability to grant I guess it would be a new trial, Mr. Kerr? Would that be the correct statement? It would be a new hearing before the commissioners?
That's what I guess it'd be a motion for reconsideration or motion for new trial on the final judgment, because that's what we're at now. But we don't have that. So
right. So it would be a rehearing, it'd be a retrial, and there's a lot of incurred expenses that the taxpayers are going to have to incur by having these judges go back and reassess their fees and submit another bill. So there's a lot of moving parts other than just giving, you the opportunity to rush an appraisal. And then the next question is, was every opportunity afforded to Mr. Trevino to be present, to make an announcement, to make himself available so that he could have his hearing? That's the reason why it was important to know if the numbers of the judges was given to Mr. Trevino. Did he reach out to them and ask for some additional time? At that point, before they incurred additional cost of the hearing and being present, at least one being present.
Your Honor, at this point, since Mr. Trevino is under oath, and I do have a judgment that I need to protect, may I examine Mr. Trevino?
Sure, go ahead.
Okay.
Mr. Trevino, good morning. You understand that you're under oath?
Yes, I do. And that's why I don't wanna say that I'm under the impression that I did attempt to call the commissioners.
Okay.
Well,
can they check my phone to see if I did, because I was under.
Well, you can check that later. I'm asking, you're under examination right now, and so I have some questions to ask you.
Okay, go ahead.
You received an introduction letter from the Drainage District back in January of 2021, correct?
I believe I did, so I need to check back.
And you signed the certified mailing card acknowledging your receipt of that, correct?
I'm not sure if it was my wife. I don't remember signing which one, sir?
A card acknowledging that you received a letter from the Drainage District regarding this project.
At what time? What day?
In January of 2021.
I don't remember signing that, sir.
Okay. Do you remember receiving a letter, though, an introduction letter from the Drainage District?
I will need to ask my wife. Maybe she signed it.
Okay. Well, then may I publish an exhibit, Your Honor?
Yes, let me make sure that let me share the screen. You're allowed to share.
Mr. Trevino, can you see what I'm sharing on the screen?
Yes.
And you see the signature card, return signature card on a certified mailing dated January 26, 2021?
Where's,
Can you see it indicates on the certified?
I see a signature there. That's not my signature. I will need to ask my wife if she signed it. That doesn't even look like her signature either.
Okay, so your testimony is that's not either one of your signatures?
It's not my signature.
Okay, you don't recognize it as your wife's signature?
It will have to be her that sees that. Can I take a picture and send it to her, or?
Well, let's move on.
It's not my signature.
Well, let me ask you this. You were aware, you have received over the course of the past year, multiple letters from the Drainage District regarding this project, correct?
Yes, sir.
Yes. And you were served with a copy of the lawsuit that was filed, correct?
Say it again, sir.
You were served with a copy of the lawsuit that was filed in this case?
Yes, sir.
And you were served with a copy of the order setting hearing in this case for the commissioner's hearing?
Yes, sir.
Yes, sir. And you also, at one point before the lawsuit was filed, you received a phone call from me, didn't you?
Yes, sir.
And I indicated to you that we were looking to negotiate. Do you recall that?
I don't recall that, sir.
You don't recall that? Do you recall telling me that you were not interested in selling the property? Do you remember telling me that?
It could have been true, yes.
Okay. You did not appear at the commissioner's hearing, correct?
No, sir.
But you did receive an award of the commissioners through certified mail, indicating that the commissioners had awarded the $82,000, correct?
Yes, sir.
You did not file any objection to that award within 20 days of receiving that award, did you?
I went to your office, sir. I don't know if you remember, and I was looking for you because I wanted to know if the meeting had been heard, and I left a bunch of messages, and I will call you and you will not answer. I wanted to know because, and you told me if I had any concerns to write a list of concerns and that you will take them to the drainage district.
Okay, and that's right. And you had some issues regarding the irrigation line, and I told you you could contact the irrigation district to work on those, correct?
No, sir. You said they will contact me and they never did.
Is it your testimony that you haven't spoken with anybody from the drainage district regarding the irrigation line?
I went to there and I spoke to them, but because I had to go all the way to the drainage district and talk to them, I did spoke to them.
Right, as I indicated that you could do. You did not. My original question was you did not file any objection to the award of the special commissioners, correct?
I didn't know they had the hearing, sir. I got it real, I didn't even get it after 20 days, I believe. I got it real, that letter was past the 20 days that you're saying after remember, when was it was November 18 when I had the hearing? When you all had the hearing?
My question is, you were sent a certified mailing indicating that the commissioners had made an award, correct?
At what time? What date?
I'm asking you whether you received it.
I received it real late, sir, not in time to contest it.
Well, when did you receive it?
I don't have it with me, right? Does it say? But it was past the 20 days.
No, well, what month did you receive it?
Yeah. It says here on December 10.
Okay, so on or before 20 days after receiving that letter, did you file any objections with the court?
Well, I went to your office and I
okay, hold on. I'm asking you whether you filed any objections after receiving that letter.
Well, it was through the holidays. I did it afterwards, sir.
So my question is whether you filed any objections after receiving that letter.
I did it after, but not at that time.
You when did you file objections to the special commissioner's award?
It was on believe February Let me see if I can find the letter.
Sometime in February, correct?
Yes, sir.
Okay, Your Honor, I have no further questions for Mr. Trevino.
I do have a question for you, sir.
I'm not here to answer your question, sir. I'm not a witness.
All right, Mr. Trevino, I'll allow you to ask a question to the court, and then if it's something that I'd like Mr. Kerr to answer, I can ask him to answer. But what is your question, Mr. Kerr? But directed to me, not to Mr. Kerr.
My question is why he didn't inform me that I could attend the hearing by Zoom. That is my question, because I told him we could not go, we cannot appear. And
Okay.
he didn't give us that option to appear.
So here's the other thing, Mr. Trevino. I was under the impression, maybe because I was speculating, and we should never speculate in court, right? That's why that's an objection that people always raise, because it calls for speculation. And I was speculating that we were talking about the fact, and I thought you were on to something here, Mr. Trevino, when you were claiming that, the 20 days was from the date of the hearing. But Mr. Kerr, the date that for him to file his response is not from the date of the hearing, but from the day he receives notice of the final judgment that the commissioners have awarded. And that was in mid-December, right?
That's correct, Your Honor.
Okay.
That's what the witness just testified to.
Right. So he is untimely from the date that he received even notice. I mean, he received the notice of the judgment, not from the date of the hearing.
That's correct, Your Honor. You go by the date that the certified mailing was sent by the clerk, and then your clock runs from that day. And we didn't file for a final judgment immediately thereafter. We probably waited 45 days before proposing a final judgment. So, but no objections were filed within the requisite time period, and really no objection was filed until, if you want to call it an objection, until mid-February or a week ago or so.
Right. I think it was a week ago, because the court set it up for a hearing immediately after hearing that there was a concern. And I wanted to have a hearing because I wanted to know I obviously wanted to let the landowners, discuss and say their piece and to give me information, because I don't have the information. Okay. Mr. Trevino, these are tough calls that I have to make.
Yes, sir. Can I make another comment, sir?
Sure.
It's through the holidays, sir. And I did make I'm not an attorney. I made contact with Mr. Kerr, and he told me to make a list. And as soon because of the holidays, to turn it in after the holidays. He's the one that told me to turn it in after the holidays.
Well, but the problem with that argument, Mr. Trevino, is that the whole month of January, you had let me say I give you the holidays, right? I give you all the month of December, and I will get you into the second week in January.
Right.
And I add 20 days to that. That puts us at the end of January, and you didn't file your objection until the end of February.
I was told, sir, that 20 days were because I try to get some legal assistance from an attorney, and he says your 20 days are up. It's over. Then my neighbor went to court, and he said that they had told him that I could file. So I went and filed, but I was under the impression that my 20 days were already over. That's why I didn't do anything at the month of January. Then my neighbor said, Tony, just go and file. But all this time, I was under the impression, because it happened in November. I'm not an attorney. I don't know the laws.
Right.
I was counting from November 18, when they had the hearing, and they said, well, my 20 days are over. I did try to reach to Mr. Kerr and see if I could get a little more of a just hearing, but they didn't. I feel like I didn't get a just compensation, sir.
Right. Obviously, Mr. Trevino, this has always been about compensation, right? It's about, if you were happy with the amount that they awarded you, if they awarded you $1 million, we wouldn't be here.
Exactly, sir.
And so it's always about compensation. It's about the feeling of the fact that you weren't compensated sufficiently.
Properly, yes.
Properly. Look, let's just, I want to be fair to you, but I also need to be fair to the taxpayers.
Okay.
Opening this case up again
Mhm.
puts additional costs on the taxpayers because another 3 additional judges will be appointed to hear this case, and there will be additional fees that the taxpayers, I'll bet through the drainage district, but because they're a taxing entity, they will have to pay, and therefore the taxpayers are incurring this cost. So I have to be fair to both parties. The taxpayers, which you, Mr. Gonzalez, we're all taxpayers. Mr. Kerr is a taxpayer. We all have to be cognizant of that. And I think that in this situation, although the law is sometimes, the law is just and right. We may not always like it. We may not always agree with it. But when you look at it and you take a step back and you don't put yourself emotionally involved in the situation, as I'm sure we've got people that are logged on here listening, lawyers, other members of our community, they can understand that, certain safeguards are out there to protect people. They have a right to appeal. They have a right to have a rehearing. But in this situation, we exhausted that because no objection was filed within the right period of time. And the law has to look at that, and we have to look at it and say, what is the reason for the fact that a hearing wasn't held? What was the reason for the fact that an objection wasn't filed timely? Was there a holiday? Okay, well, even if I give you the holidays, and although, I'm giving you almost an entire 3 weeks because of the holidays, so to speak. But we're not talking about a legal holiday. And then we're talking about a whole month and a half, almost a month and a half, untimely filed. And because of the cost that this would cost the taxpayers, if I would reopen this, unfortunately, Mr. Trevino, at this time, the court will not reopen this case and will allow the judgment to stand.
Sir.
Yes, sir.
Can I pay for that expense of the commissioners?
Well, it doesn't change the fact, Mr. Trevino, it doesn't change the fact that there's still other expenses that are going to be incurred. There's the commissioners, there's, having the drainage district incur the time for their appraisers, right, Mr. Kerr? Who are
Appraisers, attorneys. And Your Honor, I would just add that there's not even really those are all astute points, right? The cost to the taxpayer, but there's just no legal basis to do it.
Right. Yeah, but even if I felt that it was, just in the interest of fairness, I think whatever Mr. Trevino is hoping to gain in the terms of whatever he feels he should be entitled to more in compensation, he's going to lose it in the sense of I'm going to make him incur the entire costs, right? So you might be looking at upwards of $10,000 in costs, and at this point it's more about fairness, and it's more about being just. And while you may not be happy with the amount, and maybe an adjacent landowner may have received more, may have received less, I don't know. But if you're talking, I'm assuming in these type of condemnation hearings, when a drainage district comes in, they're taking chunks of land to lay irrigation canal or widen the canal or something of that sort, and so they're taking property from adjacent landowners, right? And so a lot of times adjacent landowners may get different amounts of money because of arguments that are made, and I don't know, maybe you feel that that's the reason. But when again, without going into any more, because I don't know the details,
the only objection, sorry, is that how come they didn't tell me about Zooming? If the other commissioners were able to Zoom, they should have given that option to us too.
And while I can appreciate that, Mr. Trevino, and I can understand that, we're still talking about the time that you filed your objection. If you would have filed this objection in early January, then I would be a lot more understanding of the fact that, you know what, you didn't give him an option. That option was available, Mr. Kerr. It's within the 20 days or within the holidays, and I'm giving him an extra couple of days. I would have granted that because the law allows it. But in this situation, you're outside of that timeline, and because of the fact that it's an additional expense, and I'm balancing your interest with the interest of the taxpayers, with the interest of the drainage district, with the interest of this project proceeding. At this time, I sincerely understand your situation.
Yes, can I make another comment real quick, sir?
Go ahead.
I was misled because I did get the notice, but it said 20 days. And when I saw the date that they had the hearing, I'm not an attorney. I honestly thought that it was already expired, the 20 days.
Yeah, and again, I think that is not a sufficient legal argument, because you could have filed it immediately and then made the argument that, you just were made aware of it. In this situation, clearly, we're outside of that window. I totally, these are the tough parts of our job, Mr. Trevino. These are the tough parts where I have to tell people that, we can't be here. We can't assist them in what they want. But in this situation, I think it's a function of you're just unsatisfied with the amount of money that the judges awarded. And I think that all relief was afforded to you for the opportunity to voice your concern and voice your objection. We're outside that window when balancing the fact that I'm trying to balance your interest and the interest of the drainage district, which is an entity for Hidalgo County and the taxpayers of this county. The court is of the opinion that this case that the judgment should remain and will remain at this time.
Your Honor, can I ask a question, sir?
Yes, sir, Mr. Gonzalez.
Okay, I'm just a little old country boy and naive and all of that. I just have a question, and I'm not obviously an attorney, nor do I play one on TV, but I understand what your arguments are, but beyond that, has he forfeited his right to take it to district court at this point?
Mr. Kerr, I believe, and I'll allow the attorney to answer that because that's a legal question.
And I will judge, these cases are not appealed to district court. That's not how that works. So there's things you can do on a judgment, but these don't go to a district court after this. We have a final judgment in the case.
Mr. Gonzalez, any other question?
No, sir. No, Your Honor.
All right, thank you. Again, Mr. Trevino, I understand, I sympathize with you. I understand your concern. I think that in this situation, the remedies were made available to you, and they just weren't exercised. And that's, I don't want to put the blame on you and say it's your fault. I'm just here to say that I'm applying the law, and I'm applying the facts, and I'm applying the situation and trying to be just and right all the way around to everybody involved in this situation. And in this situation, the court feels that that's a fair. I'm not even making a comment about whether you were paid a fair amount. I'm just making a comment that the decision that I'm making is fair, given the facts and given the situation about notice and the fact that it was over by about 2 months, when in reality, the law says that it should be 20 days.
I have nothing further, Your Honor. May I be excused?
Mr. Trevino, Mr. Gonzalez, and Mr. Kerr, all three of you are excused. I appreciate your time and your arguments.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, guys. All right, Mr. Kettler.
Good morning, Judge. Good to see you again. I'm here on a couple debt claim status conferences as well as a motion for default.
All right. Let's start with the first one.
Yes, sir. First one's going to be CL 182865H Portfolio Recovery Associates LLC and Rosario Reina.
All right. Is Miss Rosario Reina present? Rosario Reina? Rosario Reina. If you're on mute, please unmute yourself. Rosario Reina. Court's going to go ahead and take judicial notice of all documents in the court's file. This case is set for default judgment hearing this morning. Rosario Reina was called out. No response. You may proceed.
Yes, Your Honor. Your Honor, this case is a debt claim originally assigned by the Synchrony Bank's Walmart original creditor. After a period of non-payment, it had been assigned to the plaintiff today, Portfolio Recovery Associates LLC. The court's taken judicial notice of all documents on the court's file, as well as plaintiff's motion for default and attached documents thereto. Accordingly, plaintiff is respectfully requesting judgment in the amount of $871.21.
All right, so that's 871.21. Is that correct?
Yes, sir.
All right. Court will go ahead and grant default judgment in the principal amount of $871.21 plus cost of court. That relief is granted. All right, your next case.
Next case, Judge, is CL 183338H, Portfolio and Avendano.
All right, is Laura Avendano present? Name sounds familiar. Has she made an appearance before? I have a note here that she was to have communicated with the plaintiff to resolve the matter. To your knowledge, was that done?
To the best of my knowledge, Judge, I'm not aware of that having been done. Otherwise, they would have canceled the hearing and not had me appear. I did have a note from the last hearing from the large default judgment docket last month that she had come online, said to the best of her knowledge she was getting through the process of settling the case. I haven't been communicated that, so I've been instructed by the client just to request a bench trial setting.
Okay, so Mr. Kettler, this is a case where she was here. We did take her information. However, the court did not give her notice. So I'm going to postpone and push, not for a bench trial, but the status hearing. And I'm going to ask that my staff please give her notice as we should have done. And so the court's going to go ahead and reset this case for status for 45 days.
All right, understood, Judge.
April 13th? All right, April 13th, 2022, 9:30, and the court will send notice to her via the information that she provided to us that day when she made a general appearance so that she can get notice.
All right, thank you, sir. I've got that down. Are you ready for my next one?
Yes, sir.
Okay, CL 184677H, Portfolio and Valdez. And Judge, that's a pretty similar situation as the last case. There was a question as to finalizing the settlement. Plaintiff's office, to the best of their knowledge, it hasn't communicated any resolution to that. And so they've asked that I request a bench trial setting.
Okay, this one did get an email from our office for today, and Abraham Valdez, it doesn't look like Abraham Valdez is present. So on this one, I can give you a bench trial since we did give notice and it was sent to them to their email. Bench trial date. Whatever, yeah, that's fine. Right. All right, we'll do the 14th, 4/13 again in the morning at 9:30 for a bench trial.
All right, I've got that down, Judge. And may I be excused till the 2 p.m. docket?
Do you have number 9 or 8 or 9?
Judge, these are the only 3 that the firm's assigned for me, and I don't have the court's docket. I have the Odyssey portal pulled up. Who would those defendant names happen to be?
Alberto Hinojosa, CL 184105H.
I'm sorry, Judge, my page needs to be refreshed. Let me go ahead and double check that for you. And I see that this was also part of the large default docket from last month. Looks like the firm, and without having the documentation on file in front of me, it looks like the plaintiff's firm had submitted another motion for continuance, and I've assumed that would be related to the similar reason for the last one for settlement purposes.
Let me do this. I'll give you the same date on this one. Let the firm know that The case will be reset for April 13th at 9:30. And that is for CL 184105H. All right, how about CL 192076H, Portfolio Recovery Associates versus Eduardo Gonzalez? Eduardo Gonzalez? I have the same notes, status conference hearing. Default judgment was heard on 2/9. Settlement document signed and returned to Portfolio Recovery. I'll give you the same date, 4/13, so you can look into that.
Okay, understood, Judge.
And these will give notice to the defendants as well.
All right, and I believe with those additional two, that should be all my cases until 2 p.m.
Perfect. Thank you so much.
Thank you, Judge.
We'll see you then. All right, let's go ahead and call F 3384-21-8 in the matter of the marriage of Denise Cruz and Juan Hernandez Jr. All right, good morning, Ms. Cruz.
Good morning.
All right, is Juan Hernandez Jr. present, or do you know his whereabouts?
I don't think he's present. I don't see him.
Okay. And you are the petitioner in this matter, is that correct, for this divorce?
Yes.
All right, give me 1 second while I look up to see if you submitted a final decree of divorce. Okay, Ms. Cruz, can I have you please raise your right hand? Do you
Yes.
swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Are you the petitioner in this divorce action with Mr. Juan Hernandez Jr.?
Yes.
Prior to filing this petition for divorce, which was filed on July 19th, 2021, had you lived in the state of Texas for 6 months
Yes.
and in the county of Hidalgo for 90 days?
Yes.
During the course of your marriage, were any children born or adopted that are currently under the age of 18 or still in high school?
Yes.
Can you please state the names of those children for the record?
Matthew Daniel Hernandez, Emily Danielle Hernandez, and Jacob Anthony Hernandez.
Have you and Mr. Juan Hernandez reached an agreement with respect to possession and access of those minor children?
Yes.
And has that been laid out in the final decree of divorce that you executed and signed?
Yes.
And was any community property acquired during the course of your marriage?
No.
You are asking to be appointed joint managing conservators, you and Mr. Hernandez, of the minor children. Is that correct?
Yes.
And does the final decree of divorce speak about child support, and have you reached an agreement with respect to child support?
Yes.
And that amount is $480, is that correct?
Yes.
And you feel that this is a just amount for your support of the children?
Yes. Mm-hmm.
I apologize, I'm scrolling through the divorce decree, just looking at the highlighted parts to make sure that I ask you the right questions.
Mm-hmm.
You are asking the court to order that he pay $75 in medical support, is that correct?
Yes.
Has your marriage to Mr. Hernandez become insupportable as a result of a conflict of personalities which destroys the legitimate ends of the marriage relationship, which in essence means neither you nor he can continue to be married, and you're asking the court to grant you divorce?
Yes.
You've taken a look at the final decree of divorce, you reviewed it. In fact, you have signed off on it. Is that correct?
Correct, yes,
And you're asking the court to grant you a divorce?
yes.
Court's going to go ahead and grant you the divorce, along with all relief that's been read into the record and prayed for by way of your pleadings, and that has been laid out in the final decree of divorce. The court's going to take judicial notice of the fact that the respondent, Juan Hernandez Jr., was served on July 23rd, 2021. No answer has been filed, and he did not appear here today. I will sign off on it right now, Mrs. Cruz, Ms. Denise Cruz, and you can get a certified copy this afternoon from the clerk's office.
Sounds great. Thank you.
Thank you.
Mhm.
We have two non-disclosures.
We're gonna submit an agreement that is gonna go ahead and file it.
Okay, so rule 11 on number 3. Rule 11 on number 3. Now, do we have Sergio Sanchez and or Rubio? I know I had, oh, there's Kennedy. Perfect.
You got me, Judge.
There's Mr. Kennedy.
Not as good looking, but smarter. I hope.
I don't know about that. I gotta go with your father-in-law. And
That's a good choice. Yeah,
he's been around the block a few times.
that's true.
All right, CL 22-0108H, State of Texas versus Mitzi Morin.
Good morning.
Good morning. What do we have here, Mr. Kennedy?
Judge, she was charged with a Class B theft, and she received deferred adjudication at a County Court 7. So we filed a motion for non-disclosure, Your Honor.
All right. Do we have Mr. Chavana?
Yes, Your Honor. The state has no objection to the plaintiff's request, Your Honor.
All right. The court was going to go ahead and grant the non-disclosure at this time. Ms. Morin, the court will go ahead and grant your non-disclosure. I will sign off on it and stay in contact with Mr. Kennedy so that he can walk you through the process after that.
Thank you so much.
You're welcome.
Have a good day.
Thank you.
You too.
Thank you, Judge. Have a good day.
Thank you. Sorry for the hold up and the wait this morning.
Oh, not a problem. It's kind of educational, I thought.
Thank you.
I know Greg Kerr with a beard is a dangerous Greg Kerr. So have a good one, Judge.
Greg Kerr with or without the beard is always dangerous.
That's true.
All right. Thank you. All right. Mr. Chavana, Mr. Heller, I'm still waiting on Mr. Sanchez. Does the state have any objection as to the non-disclosure for Alyssa Perez?
Unfortunately, Your Honor, we believe the statute does not allow for non-disclosure in either case that Mr. Sanchez is requesting for Miss, I'm not sure what her name is.
Alyssa?
Yes, that's correct.
Okay.
She
So
has-
then I would tell you just to log off and I'll take your, I'll note your non-objection, but if you have an objection, let me get him online and let's see if we can have a hearing on it.
No problem, Your Honor.
Okay, thank you. All right, otherwise that takes care of our docket. Court's gonna go ahead and log off of YouTube because it might take a while before I get Mr. Sanchez on.